Welcome to this week's episode of Winning Isn't Easy. I'm really excited about this episode, which is how doctors can destroy their disability claims, lose their license, and go to jail by doing work as a peer review doctor. Now, you may not be a doctor and you're wondering, why should I listen to this episode? But I'll tell you, because this is a problem that arises in the course of disability insurance claims, particularly when there is residual disability benefits. And the professional has lost their identity. They don't know what they want to do. They do want to work. And they come to us and say, hey, based on my disability insurance policy, is there something that I can do to give me a sense of, self-worth, but without jeopardizing my disability benefits? And this is where our speaker this week is going to address the practical realities of doing work and potentially finding yourself the subject of a criminal investigation. So I want to welcome attorney Jonathan Rose. Jonathan served in the United States Marine Corps before becoming an attorney, and he's a law school graduate from the University of Miami. He specializes in representing Florida healthcare practitioners in administrative and disciplinary actions with the Department of Health, their boards, their certifying boards, and other agency. And that means that he's involved in white-collar crime cases, including healthcare fraud. And that's where we end up having Jonathan speak with us, because unfortunately, I've had an occasion to deal with this issue. And I think it's something that's really important for our audience to understand and to understand the consequences of making a bad decision. So, Jonathan, welcome to the show.
Thank you very much for having me. Glad to be here.
Great. So can you tell us generally, what are the criminal law dangers that a physician or any professional might face when they are doing either peer review work or other types of work while attempting to collect residual disability insurance benefits?
The criminal potential liability for doing any sort of peer review work is interesting. It's not very common, but it's certainly a possibility. The problem with peer review work and the peer review statutes is that it requires any facility, licensed facility in the state of Florida, to have very defined set of parameters to do that in. They're statutorily defined. They're not negotiable. The problem is that most facilities, in my experience, don't actually have those specific parameters in place. They do these things more or less on an ad hoc basis, and peer review tends to be problematic in the sense that a lot of the time peer review isn't really done on a good faith basis. It's done because there's a grudge against one doctor or another. And if one is engaging in peer review to perhaps get rid of a whistleblower or get a whistleblower to stop blowing that whistle, so to speak, or if it is a bad faith attempt to remove someone or reduce someone's patient load or something like that, those or even have an action to get someone's license, those are property interests, and therefore that action could conceivably be fraud.
So what I typically see is my physician calls me up or my professional calls me up and says, look, I want to do something. And I can see that I can potentially do some peer review work. And they go out and they kind of look for companies that offer them the opportunity to do peer review work. Like, let's look at a person's medical records and certify them for a certain type of medical equipment or devices without ever having seen the patient. It kind of looks good, if you will, but there are all sorts of traps that anyone can fall into. So can you kind of tell us specifically in the peer review process, what are the traps that physicians or other professionals need to be looking for if they're thinking about doing something like peer review?
If one is going to be doing this, on a sort of a telehealth basis electronically, that is very problematic. That's actually a doing any sort of document review via telehealth or any sort of electronic means becomes very problematic. I've had a number of clients who have been disciplined by the Florida Board of Medicine. A number of clients have actually had federal criminal action taken against them because they have engaged in sort of some action of that nature. And if there are certain circumstances where the way that these companies who have shiny websites and seem like they're very legitimate, the way that they're presenting the records, even if the physician is acting in good faith, if they're not paying attention to the way the records are presented to them, they could be, if they say, well, this person needs some item of DME, or this person needs some sort of testing, or whatever the case may be, they could be putting themselves in a position where every single record that they sign could be a false statement. And if that's the case, then it could be, and if they're being paid obviously for their work, those could also be construed as kickbacks. So there are any number of different ways where this can be very, very problematic for practitioners.
So one of the ways you've said is looking at electronic records. What is it about the electronic records that leads to problems, and what are the other potential problems other than looking at electronic records and signing off on equipment or certain services?
Well, if one is, what's problematic is that the records are frequently not legitimate records, and if one doesn't know exactly what a person has, there's no in many cases there is no actual evaluation. The physician isn't doing anything except reviewing records and accepting the premise that those records are legitimate. And if you're doing a prescription based on that, and then you don't really know what you're doing, then you've created any number of problems for yourself.
So other than the electronic record aspect of it, what else are some of the problems that a physician could face by doing peer review work?
By doing peer review work, if you put yourself in a position where you're in a group that is, whether you think it is or not, if that group has been formed with an intent and in some sense to on a bad faith basis, to again affect someone's property right, to patients, to money, to salary, they're causing them license issues. Those are property interests, and those can be prosecuted as fraud, both on a state and a federal basis.
So the typical presentation, I guess, is there's a shiny website out there for, do you want to be a peer review physician? And it looks very attractive. What is it that would signal to you as a criminal lawyer that this is not something you want to get involved with?
I think that physicians, and this is sort of odd to say because we think of physicians as being people who think very critically, and within the constructs of what they do as physicians, I mean, certainly they normally do. But what I find is that they don't think critically once they leave the office in many circumstances. So when physicians are thinking that they want to do some sort of peer review work and they go to some sort of website, they need to be very, very cognizant about whether that website or that company is actually functioning within the parameters of the federal statutes and the state statutes. If it's a circumstance where there's providing the records, they're not doing anything else, then my advice under almost all circumstances would be that they do not accept that employment. Anything that involves practicing exclusively and through electronic means is fraught with problems, and again, that can lead to criminal problems. That can lead to civil liability under the Florida statute. One could very easily be sued for that. So there is any number of problems, and I think it really depends on the way that the records are structured. And peer review, external peer review can be a real thing, but if one is just signing up through a website to do peer review, that has the potential to be very, very problematic.
So obviously the problem, as I understand it, is that this particular peer review service is for a patient to be approved for either medication or a procedure or a piece of equipment. Would
Right.
that be correct? Okay.
DME, sure.
Right. So then I have other situations, of course, where physicians can potentially go to work for a disability insurance company or a workers' comp insurance company, looking at medical records and rendering opinions about causation or need for treatment. Uh, is that situation any different than the first situation?
It's different in the sense that it's a different mode of liability, but it's very similar in the sense that if one goes to work for a company that's doing that kind of work, and you're putting yourself in a position where you're not abiding strictly by the laws that apply to these things. So if, for instance, if a doctor is just like reviewing records and making a recommendation or a prescription essentially for testing or a prescription or a piece of DME, durable medical equipment, then you're putting yourself in a position to commit federal and state offenses. Could be false statements, could be kickbacks, could be any number of things. Again, in the long run, could be money laundering. And all of these things have really, really potential dire consequences for people's licenses. The Florida Board of Medicine, Florida Department of Health deal with these things very, very seriously. And the federal government, through HHS and a number of other agencies, are very, very active at this point. There are healthcare crime task forces that are dealing with these things, and they're very aggressive in their prosecution. So it's very important that physicians understand these things, and the amount of trouble, so to speak, that a physician get in is much more serious than one might think. Because let's say, for instance, if these folks are typically paid somewhere between $25 and $50 per patient per record that they review. Hopefully, they're not being paid on a contingent basis. If they're being paid only if they do a prescription, that is obviously problematic in and of itself. But let's assume there is no such contingency. If the doctor may think, well, how big a deal could it be? I've only been paid $40,000 over a year or $30,000 over a year, which is about what I would expect someone to make doing this. So it's spending money for a physician normally. That's not the amount of money that you're held responsible for. You're held responsible for the amount of money that is the loss to the federal government. So if a company is charging $800 for a piece of DME or $1,500 from some sort of testing, that's what Medicare or Medicaid or TRICARE, whatever the case may be, is paying for that. And if you do several thousand patients, well, that adds up very quickly, and that can be very serious. Millions of dollars of loss that some physician is responsible for, really not understanding what they were doing.
This is great, but we're going to take a quick break, because when I come back, I want to ask you about what are the typical state and federal charges, what is the typical sentence and fines, and then we'll talk about licensure. So we'll be back in a second.